In my model plan here for you, we might start with a family limited partnership. I'm simplifying here to illustrate some concepts, of course. So you can't be in partnership with yourself, but that's easily cured by having an accommodation partner. And in the interest of simplicity here, we'll just illustrate that let's assume a client has a nest egg approach in mind, as I've just talked about, and they want to protect a $1 million investment account. They'll drop that into a family limited partnership and receive in exchange a 1% interest as a general partner and a 99% interest as a limited partner. The 1% interest gives them, under state law, importantly, 100% control. The 99% interest under state law, importantly, gives them no control, but represents 99% of the value. So what we're setting the stage here for is separation of ownership from control. And by setting the stage for separation of ownership from control, we're getting ready for them to divest the ownership or the value, but yet still stay in control of assets in a fashion consistent with state law. Now, there's, of course, other features related and relevant here to the partnership. There's the charging order concept. And I know from the show of hands that some of you are beginner skiers. And that being the case, I'll take a minute and say, it varies state by state, and you always want to take a look at what the particular state provides. And in fact, a state may vary in its partnership law from its LLC law. So don't expect consistency just because you're in one state and expect their partnership law and their LLC law to be the same. But a creditor's remedy against a partnership interest or an LLC interest, a creditor's remedy is not as direct or as favorable as it would be against the underlying asset itself. So if a creditor was going after $1 million managed account, it would be easier for them. For the creditor to go after the partnership or LLC interest, it's more difficult because the remedy is, and it's not necessarily the exclusive remedy, it varies state by state, but the remedy is to get what is called a charging order. And a charging order is, in essence, a lien on the interest. And what the lien means is that the creditor can't force a distribution from the partnership, and the creditor can't force a liquidation of the partnership. What the creditor can do is sit back and wait so that if and when money comes out, then the creditor gets the money. In the meantime, the general partner stays in control of the partnership. Well, the bad news is you force a waiting game. So while the creditor can't get it, neither can the general partner. In my CCH book, there is a sample charging order, and a lot of lawyers who practice in this area talk about charging orders, but they've never really seen a charging order, and there is one in here. And they can be very, very restrictive. What kind of happens is adversary counsel drafts it and throws it under the nose of a judge, and a judge doesn't know what it is either, and so he signs it. And basically what it says is nobody can breathe without court approval. So they can be very restrictive. So it's not an ideal situation. Might be better than nothing, but just realize, things kind of get tied up there, and it forces a waiting game. Another aspect to the charging order is that Revenue Ruling 77-137 can be read to mean that the creditor becomes the economic successor in interest to the partnership interest. Therefore, the creditor gets the K1 at tax time. So if the $1 million managed account generates $80,000 in taxable income, then the tax bill goes to the creditor, whether or not any money goes to the creditor, which might be a pretty dissuasive factor to the adversary as to whether or not they get a charging order once they're educated on that result. All right. That's step one. We create the partnership, drop the $1 million in, and these interests result. Step two, we create the Integrated Estate Planning Trust. To your left, the settlor, that's just a historical designation. We have oftentimes two trustees, a foreign trustee and a domestic trustee. Note 3 will tell you that the domestic trustee can outvote the foreign trustee in most situations. Most situations. Now, that's not always the case in the design of the trust, of course, but clients like the fact that, you've seen Reuben from the Cook Islands and Anthony back here. You can wave to Anthony from Cook Islands Trustees Limited. They look like normal people, don't they? And they are, and they're great to work with, and I have worked with them for many, many years, but a client comes in and I talk about them and their company, and it's a big leap of faith for them to say, great, I like them already. So what clients like is that, we've worked with them so long, they like the fact that they've been part of the team for 20 plus years, but they also like the fact that Uncle Charlie in Kansas City can be a domestic trustee, and that Uncle Charlie, while we're in this nice and quiet period with no suits and threats, which we hope is always the case, that Uncle Charlie in Kansas City can have that kind of extra vote and call the shots on a kind of day-to-day or month-to-month basis. Then we have the protector concept. The protector usually has the ability to remove and replace the trustees and to veto various decisions of the trustees. Note 5 tells us, next to beneficiaries, the beneficial class often includes the settlor, the spouse of the settlor, children of the settlor, one or more charities. In other words, we have a discretionary trust. Trustees determine who gets how much when. No beneficiary has an ascertainable interest. Now, to plug step 1 into step 2, the settlor makes a transfer to the trust of that 99% partnership interest, and the result is that the settlor is in partnership with the trust. The settlor has 1% interest as a general partner. The trust has a 99% interest as a limited partner. You can see here we've separated ownership from control. The trust has 99% of the value. The client has 1%, but it's the 1% that represents 100% control. Again, I'll emphasize, in a fashion consistent with U.S. legal principles under limited partnership law. Now we come to funding, illustrating as well the integrated estate planning aspects of this design. At the top left, you'll see we have the last will that pours the residuary estate over to the trust. At death, the trust typically turns into the A and the B, or the A and the B and the C, or the A and the B and the C and the D trust. And then as well, because there's no rule against perpetuities in the Cook Islands, can last for 100 years or 300 years or in perpetuity, and will often be a long-term generation skipping type of trust. You'll note that under the partnership, here we have cash, stocks, bonds, managed account, art, antiques, collectibles. And those are under the partnership, which, again, in a fashion consistent with domestic partnership law, the client is permissibly controlling 100%. Note 6 tells us the integrated estate plan will involve a last will that upon the death of the client pours over the client's residuary estate to the IEPT. Other conventional estate planning documents will also be involved, durable power of attorney, health care, proxy, etc. And other planning tools will be integrated in the appropriate cases. A QPERT, a CRT, a CLT, family foundation, etc. We might consider multiple entities. We might have 2 trusts. We might have multiple entities under the trusts, multiple underlying entities, because, for example, we don't want the same partnership that holds the cash, stocks, and bonds, etc., to hold an apartment building. Because if somebody falls off the roof and hits the ground, and that apartment building is owned by a partnership, well, A, we have flow-through liability to the general partner, so we'd rather have an LLC, and B, who owns that apartment building? The partnership, and what else does the partnership own? Cash, stocks, bonds, et cetera, et cetera. So we like to put things into different pockets, different buckets, so that risk and exposure is trapped and only spreads so far. This we talk about more tomorrow. Level 1, planning distinguished from level 2. The concept is, back to this diagram, here we have an S-corp, in my example, that's held by IEPT2. Just because we've protected the stock of the S Corp by transferring it to the trust, we've protected it from what might befall the settlor. That doesn't mean we've protected the S Corp itself. The S Corp can get sued. It could have its own creditors. It's an active business. So there's things we can do to protect the assets of the S Corp. That's discussed in this step 6, but it's also in one of the articles that you have in your collection of articles. It might be the first one, I'm not sure, but it's an estate planning article from 2008, co-authored by Ed and myself and John Garland of our office. And that details some of the things and some of the ways you can asset protect for an active business or a professional practice.